Welcome back to Case Briefs with Megan. Let's make this case brief. This is another one of those cases that is kind of half con law and half family law if we really dig into it, because it does deal with the topic of what's considered a family here in the United States, but also a really essential right that you have underneath the 14th Amendment on account of the fact that the 10th anniversary of this case just passed as of yesterday. I figured today we should talk about Obergefell versus Hodges. This is a really interesting case to cover because it's not just one story that's told in this case. This case is actually kind of plucked and chosen from multiple different cases from throughout the United States that were debated on a lower court, and the Supreme Court actually decided that they were just going to take all these cases, put them together in one big case, and address a really big issue, which is, do you have the right to marry somebody of the same sex here in the United States? And with so many cases, you hear a couple of different stories. Let me tell you about a couple of them. You'll hear the story of one couple in Michigan who could not be married to each other because they were both women, yet had a commitment ceremony and wanted to adopt children. However, at that point in Michigan's time, because gay marriage was not considered valid, the children of this couple could only be adopted either by a single parent or a married couple. In this case, because they couldn't be married, one parent could adopt one child, one parent could adopt the other, but they could not be the parents to both of their children. So you have an issue there, a family unit in distress. You hear the story about one man who heard the calling to serve his nation in the military, and he just so happened to be in love with another man. They got married in one state and had to move to Tennessee, where that soldier was deployed. However, at that point in time, in Tennessee, gay marriage was considered invalid. So, as soon as they moved down to Tennessee, they were no longer considered a couple, and you need as much support as you can get as you are busy trying to figure out the best way to defend America and its security. Finally, you might even hear the story of the namesake of this case, Obergefell. You have an Ohio State couple who are very much in love but happen to be two gay men. At that point in time, in Ohio, gay marriage was considered invalid. However, they decided to go to New York to be married because one of the members of this couple had ALS and was beginning his decline. So they went and they got married in New York, and then they immediately flew back. And all one of the members of this couple wanted, after his spouse unfortunately passed away, was to be named as his spouse on the birth certificate, which Ohio State was not allowing for. And so the Supreme Court has to take a look at all of these cases and decide for themselves, okay, is it a violation of the 14th Amendment with the Equal Protection Clause if one state invalidates another state validating a gay marriage? AKA, is it okay to be married to somebody of the same sex or gender here in the United States? Can that be considered a family? And as we learned 10 years ago, yes, you do have a constitutional right to marry whoever you want, and you cannot be invalidated. That marriage cannot be invalidated if you cross state lines simply on the basis of the sex or gender of your partner. It looks at these couples and they say, look, your right to marry whoever you want is inherent to an individual's autonomy to choose that person, to choose who you want to marry. That is a choice that you have a right to have here in the United States. The justices look and they say, look, marriage, we support marriages and we want people to get married because then you have a union where two people are committing to support each other like no other. You shouldn't have to invalidate something like that on the basis that two people who want to commit to each other just happen to be people of the same sex. Justices also look and they say, look, we also not only support marriages, but we support the formation of families. Some of those families look different than other families. However, it's a family nonetheless, and we want to support the fact that people who may be of the same sex want to form families. And of course, we want to support your ability to create a family with somebody and to create families across the United States. In a really cool final reasoning, the justices look and they say, look, marriage is a cornerstone of our societal beliefs. We have no place to get involved as to whether that is somebody of the same sex or somebody of a different sex that you want to get married to. We just know that that's a cornerstone of our beliefs here in the United States. We're not going to stop you from getting married. Of course, as we know, this now means that even though there were some states that had allowed for gay marriage and believed that it was valid, this law now spread all over the United States, which meant that no matter where you went, whether you were married to a man or a woman, and whether you happen to be married to a man or a woman, your marriage is no longer going to be considered invalid just because you crossed another state lines. And that is a really cool thing. Keep in mind that this is a very new rule. This was just passed in 2015. So gay marriage here in the United States as a nationwide concept has only been around for the past 10 years. And we're lucky that we are able to celebrate that now 10 years later, even though things are kind of up in the air right now. If this case teaches you anything, love wins.